Right now, there are approximately 59 million Americans doing gig work, delivering food, driving strangers across town, assembling furniture in other people's homes, running grocery orders, doing care work coordinated by apps that track every minute of every shift. Most of them are not employees. That is the legal reality. Formally, officially, under the contracts they signed, they are independent contractors, which means in most states, they do not receive minimum wage protections. They do not receive overtime. They cannot collect unemployment insurance when the work disappears. They have no access to workers' compensation if they get hurt. No sick days. No health coverage through the platform. And if the company decides the relationship is over, it can deactivate their account with no notice, no appeal, and no explanation required by law. This is where the debate sits right now in the United States. The Trump administration has been moving to roll back a Biden-era Department of Labor rule that made it harder for companies to classify workers as independent contractors. State legislatures from New York to California to Texas are in active conflict over the exact same question. DoorDash, Uber, and Lyft have deployed lobbyists simultaneously across dozens of state capitals, spending at a scale that no labor advocacy organization can match. Seattle passed a gig worker minimum wage law in 2023, and the aftermath was messier than either side predicted. California passed Proposition 22 in 2020, locking gig workers out of employee status in that state after the platform spent an estimated $200 million campaigning for it. The companies call what they offer flexibility. Some workers call it the same thing. Others call it something closer to the conditions that American labor spent a century fighting to escape. And here's what is striking about this debate, if you listen to it carefully. Almost nothing about it is new. The specific words being used today, flexibility, independence, individual agreement, market efficiency, were used in nearly identical arguments before Congress in the 1930s. The logic is so similar that it is worth asking whether we are watching a new debate or watching an old one restart with a new vocabulary. This isn't the first time. And what happened the last time changes everything about how you see this moment. To understand what happened last time, you have to go back to New York City in the early years of the 20th century. By 1910, the garment industry was the largest employer in New York City. The city produced roughly 70% of all women's clothing made in the United States. The people doing that work were overwhelmingly recent immigrants, young women from Eastern Europe and Southern Italy, most of them Jewish or Catholic, many of them teenagers, most of them sending money home to families who depended on them. They had come to America with almost nothing. The generation that built the Fair Labor Standards Act answered the first version of this question in a specific historical moment with specific political consequences. Your generation is being asked to answer it again. The people versus two sides. One story. You decide. They worked because there was no alternative. The conditions inside those factories were documented extensively at the time. Factory floors were packed beyond any reasonable safety standard. Ventilation was poor. Workdays ran long. 10 hours was standard. 12 was common during the busy season. The pay was structured to minimize cost to the employer. Workers were often paid by the piece, which meant that any time spent waiting for materials, fixing a machine, or dealing with an interruption came directly out of their own earnings. The risk of slow periods was carried not by the company, but by the worker. The Triangle Shirtwaist Company occupied the top 3 floors of the Ash Building at 23 to 29 Washington Place in Greenwich Village. It was considered a modern building. The owners, Isaac Harris and Max Blank, were successful businessmen in the shirtwaist trade, the fashionable lightweight blouses that working women wore at the turn of the century. On those upper floors, around 500 workers spent 6 days a week at sewing machines. Certain exit doors were kept locked during the workday. The owners said this was to prevent theft and to keep workers from leaving before their shift ended. Fire safety inspections had occurred. The building was considered to meet the standards of the era. On Saturday, March 25, 1911, at approximately 20 minutes to 5 in the afternoon, a fire started on the 8th floor. A bin of fabric scraps and tissue paper patterns caught flame. The cause was never definitively established. What happened next was determined by the physical facts of the building. The materials inside were highly flammable. The floors were densely packed, and several exits were not accessible. Workers on the 8th floor had time. They ran for stairwells, climbed to the roof, and some were helped across to an adjacent building by students at New York University. The 9th floor did not get sufficient warning. By the time workers there understood what was happening, fire was already in the stairwells. They went to doors. Some of the doors were locked. An exterior fire escape filled with people and then collapsed under the weight. The freight elevator made a few runs and then stopped. The fire department arrived, and their ladders reached the 6th floor. The fire was on the 8th, 9th, and 10th. 146 workers died on March 25, 1911. Most of them were women between 16 and 23 years old. Many of them went to the windows. People standing on the sidewalk below watched them fall. Among those people on the sidewalk was a 29-year-old reformer named Frances Perkins. She had been having tea at a friend's apartment on Washington Square, 1 block away, when she heard the fire engines. She ran to the building. She stood on the street and watched. Perkins described the experience in extensive detail in later interviews and in her memoir. She described the sound, the smoke, the faces she could see in the windows. She carried the memory for the rest of her life. She said it changed her understanding of what the argument about labor conditions was actually about. It was not a dispute about the preferences of individual workers. It was a question about what happens when one side of a negotiation has all the power. Frances Perkins became, 22 years later, the United States Secretary of Labor under Franklin Roosevelt. She was the first woman to serve in a presidential cabinet. She held that position for all 12 years of the Roosevelt administration, longer than anyone before or since. She was a principal architect of the labor framework the New Deal built. In interviews late in her life, she returned again and again to the afternoon of March 25, 1911. The investigation that followed the Triangle Fire was serious and sustained. The New York State Factory Investigating Commission, led by state legislators Robert Wagner and Alfred Smith, spent years examining factories across the state. They visited facilities. They interviewed workers. They documented what they found: locked exits, blocked aisles, non-functional fire suppression, child labor, 12-hour days with no legal limit. The evidence they assembled helped move 56 pieces of labor legislation through the New York State Legislature between 1911 and 1913. Other states followed. The reforms were real, but they were patchwork. They varied state by state. They covered some industries and not others. They did not touch the fundamental legal question Triangle had exposed. What does a company owe the people who perform work for it? And how much of that obligation can be negotiated away through a contract? Isaac Harris and Max Blank, the owners of Triangle, were tried for manslaughter in December 1911. They were acquitted. The jury deliberated for less than 2 hours. The judge's instructions had made the standard for conviction very high. The prosecution had to prove that the owners specifically knew that the particular exit workers tried to use on the day of the fire was locked. 3 years later, Harris and Blank were found to have locked factory doors at a different facility. The fine was $20. The public reaction to the fire was unlike anything New York had seen. In the days after the fire, the bodies of the victims were laid out at a pier on the East River for identification. On April 5, 1911, Approximately 80,000 people marched through the streets of Lower Manhattan in the rain as a funeral procession. Hundreds of thousands more lined the sidewalks. The city had not seen mourning on that scale in living memory. At a mass meeting at the Metropolitan Opera House shortly after the fire, a labor organizer named Rose Schneiderman spoke from the stage to an audience that included some of the most prominent civic figures in New York City. She told them that this was not the first time women had been burned alive in a city factory, and that it would not be the last until the workers themselves organized for their own protection. She told them that a label of goodwill from the wealthy and the powerful was not a substitute for actual power. Her speech was recorded and printed. It circulated. It is still read. The political energy of that moment was real, but political energy and legislative change are two different things, and the gap between them is where most reform disappears. Through the 19-teens and 1920s, the underlying structure of industrial labor did not change significantly. Workers in many industries were subject to what labor historians call the yellow dog contract, an agreement signed as a condition of employment in which the worker promised never to join a union. These contracts were legally enforceable. Refusing to sign meant no job. In company towns, particularly in coal mining and textile regions of the South, the relationship went further. Workers lived in company-owned housing and shopped at company-owned stores, sometimes paid in company scrip, currency that could only be spent at those same stores. A man could work for a year and end up more indebted to his employer than when he started. The 1920s are often remembered as a period of prosperity and expansion, and in some measures they were. Industrial output grew. Consumer goods proliferated. The stock market climbed year after year. But the distribution of that prosperity was extremely uneven, and the statistics of the era show it clearly. Between 1923 and 1929, worker productivity in American manufacturing rose by roughly 32%. Wages rose by about 8% over the same period. The gap between what workers produced and what they were paid was not a rounding error. It was policy, made possible by the legal and contractual structures in place. These arrangements were always described, by the companies that ran them, as voluntary. The workers had chosen to sign the contract. The workers had chosen to live in the company housing. Nobody was forcing them. The argument was that any attempt to regulate these private arrangements was an interference with the free agreement of willing parties. That was the language. That was the principle being defended. The Depression ended the argument, at least temporarily. In October 1929, the stock market collapsed. By 1932, 1 in 4 American workers was unemployed. Industrial production had fallen by nearly half. Banks were failing. Farms were being foreclosed. And the people with the least protection, workers without union contracts, without savings, without any legal claim on their employers beyond the terms of their individual agreements, fell first and fell hardest. The system that had been described as natural, efficient, and mutually beneficial had left millions of people with nothing to fall back on. Franklin Roosevelt won the 1932 election, carrying 42 of 48 states. He appointed Frances Perkins to lead the Department of Labor. She came to Washington with a list she had been building for 2 decades, and the Depression had made the political conditions for passing it real in a way they had never been before. The list included a federal minimum wage, maximum work hours, unemployment insurance, workers' compensation, the end of child labor in interstate commerce, the legal right to form a union without being fired for it. The business community opposed these proposals with considerable force and considerable money. The National Association of Manufacturers argued that minimum wage laws would destroy small businesses and raise prices for consumers. Individual employers argued that their workers were satisfied with existing arrangements and that government was trying to fix a problem that didn't exist. Some testified that their workers specifically preferred the flexibility and informality of current conditions over the rigidity that legal protections would impose. The language was specific, and it is worth pausing on. The argument was not only that these laws would hurt business. The argument was that workers themselves did not need or want the protection being offered. That the government was overriding the genuine preferences of the very people it claimed to be helping. It took 5 years of legislative fighting and constitutional challenge to move the core legislation through. The National Labor Relations Act was signed in 1935. It gave workers the legal right to organize and bargain collectively and made yellow dog contracts unenforceable. The Fair Labor Standards Act was signed on June 25, 1938. It established the first federal minimum wage at 25 cents an hour. It set a standard workweek and required overtime pay at 1.5 times the regular rate for hours beyond it. It placed effective restrictions on child labor in industries engaged in interstate commerce. The exclusions matter and should not be passed over quickly. Agricultural workers were excluded from these protections. Domestic workers were excluded. The exclusions mapped, not coincidentally, onto the categories of workers who were most likely to be Black or Latino and least represented in the political process that produced the law. That history is long, serious, and its consequences ran for decades. It is not a side note, but the legal principle was now established as federal law. A company has specific, non-negotiable obligations to the people who perform work for it, and those obligations exist regardless of what any individual contract says. Below a certain floor, you cannot go. For roughly 4 decades, the floor held. Now come back to 2026. The argument being made today by platform companies in courtrooms and state capitals is not, at its structural core, different from the argument manufacturers made before Congress in 1933. The surface details are completely different. The underlying logic is nearly identical. In 1933, the employers said, "Our workers prefer individual arrangements. Government interference disrupts a system that benefits everyone. These proposed protections will eliminate the flexibility that makes this industry work." In 2026, the platforms say, "Our workers prefer flexibility. Government interference disrupts a system that benefits everyone." Reclassifying these workers as employees will eliminate the flexibility that makes this industry work. The word flexibility appears in congressional testimony from 1938 defending existing labor arrangements. It appears in platform company statements from 2025 and 2026 defending their current classification model. This is not a coincidence of vocabulary. It is the same argument with the same logic applied to a different industry in a different century. What is genuinely the same across 90 years? The core question. When a company depends on a person's labor to generate its revenue, what does it owe that person? Does the name on the contract change the substance of the relationship? What is genuinely different? The technology has changed the nature of the work in ways that are real and matter. In 1938, a factory worker was physically present in a facility the company owned, operating machinery the company owned, producing a product the company sold. The relationship was visible and local. Today, the work is distributed across 50 states, managed by algorithm, and the people doing it may never meet each other, may never be able to coordinate, are kept structurally separate in ways that make collective action extremely difficult. The 1930s factory floor made it possible for workers to look at the person next to them and start a conversation about wages. The 2026 gig model is designed, whether intentionally or as a consequence of how it works, to make that nearly impossible. The isolation point deserves a moment. It is not a secondary detail. One of the things that made the New Deal's labor protections politically possible was that workers in the 1930s could see each other. They worked in the same building, at the same machines, under the same foreman. They could talk on breaks, walk out together, compare what they were paid, and understand that what they were experiencing was not individual bad luck, but a collective condition. That visibility was the precondition for everything that followed. A gig worker in Phoenix does not know what a gig worker in Philadelphia is earning, or what terms they accepted. The platform knows both. The workers do not know each other. That asymmetry of information is built into the architecture of the business model, and it is not incidental. There is also a genuine difference in the nature of individual choice. Many people working in the gig economy have made a real calculation that the arrangement suits them. Parents with unpredictable caregiving responsibilities, people supplementing income from other work, people who found traditional employment schedules unworkable for their specific circumstances. That flexibility has real value for real people. It is not purely a fiction constructed to serve the platforms. But what makes the comparison difficult to set aside is this. The choice available to a gig worker is generally not between flexible contract work and regular employment with the same company. These platforms do not offer traditional employment as an alternative. The choice is, accept the contract as written or look elsewhere. In 1930, that was also the nature of the choice. Sign the Yellow Dog contract or find another employer. Here is how the people who believe nothing has changed make their case. In testimony before federal and state legislative bodies over the past several years, gig workers have described the experience of sudden account deactivation, losing access to their income with no warning, no appeal process, no explanation. Because they are classified as independent contractors, they cannot file for unemployment insurance. Because they are not employees, they have no wrongful termination claim. The platform removes their access, and there is, in the most literal sense, no one to call. That story is not new in American labor history. It is, in almost exact terms, the story that reformers spent the first 4 decades of the 20th century trying to change. People who hold this position point to how the platforms actually function in practice. The company sets the price the customer pays. The company determines the route the worker takes. The company monitors performance in real time and adjusts what work is offered based on that monitoring. The company can end the relationship instantly and unilaterally. These are not the characteristics of a commercial relationship between two independent parties engaged in a voluntary transaction. These are the characteristics of an employer directing an employee, with the legal obligations of that relationship removed. The classification, this side argues, is a mechanism, not a description. Now here is how the people who believe this comparison is wrong, or dangerously oversimplified, make their case. Economists who have studied these labor markets carefully point out that the New Deal framework was built for a specific kind of work: full-time, single-employer, place-based. Applying that framework to gig work may help some workers while creating real problems for others. When Seattle implemented its gig worker minimum wage law, some workers saw their hourly earnings increase. Others saw reduced offers from the platforms during certain hours because the economics of specific routes changed. The law created winners and losers within the same workforce, and the distribution of outcomes was not uniform. That is not necessarily an argument against the law, but it is evidence that moving workers into the existing employee category does not automatically improve everyone's situation. The more compelling argument from this side is about portable benefits, protections that travel with the worker across platforms rather than being attached to a single employer relationship. A gig worker doing 15 hours for one app and 12 for another does not fit cleanly into a framework built around 40 hours with one employer. What that worker might actually need is access to health coverage, unemployment insurance, and retirement contributions that accumulate based on total hours worked, regardless of which platform the work came through. That is a solution designed for how work actually functions in 2026. The binary of employee versus independent contractor was not. Washington State has been piloting a version of portable benefits for certain gig workers since 2023. The early results are contested. Supporters cite improved access to paid family leave. Critics point to compliance costs that smaller operators have struggled to absorb. The experiment is ongoing, and the data is still coming in. But it represents an attempt to build something genuinely new rather than retrofitting a 1938 framework onto a 2026 workforce. Whether it works is a different question from whether the attempt is the right direction. And there are gig workers on both sides of this debate. That matters. The 59 million people doing gig work are not a uniform group with identical circumstances or identical interests, and a single policy answer applied across all of them will not serve all of them equally. The retired school teacher who drives for Lyft 12 hours a week because she wants something to do and values the schedule control is in a materially different situation than the man who drives 60 hours a week for 3 apps because it is his only income, and he has no cushion if any of those accounts gets deactivated. Both of those people exist. Both of them are real. The question is what the law should be designed around: the person with more options or the person with fewer? That is the same question Frances Perkins was asking when she walked into Washington in 1933. It was not easy then either. The people who opposed the Fair Labor Standards Act were not uniformly villains. Some of them genuinely believed that regulation would hurt the workers it was meant to protect. Some of them were right about specific provisions and wrong about others. Policy is not a morality play, but here is what the New Deal actually settled, and what it didn't. It settled that an employer cannot require a worker to give up basic legal protections as the price of a job, not because workers are incapable of making decisions for themselves, but because when one party to a negotiation has all the leverage and the other has very little, the word voluntary stops meaning what it's supposed to mean. The 12-hour day was accepted voluntarily. The locked exit was in a building workers showed up to every morning by their own choice. The Yellow Dog contract was signed freely. Frances Perkins understood after March 25, 1911, that voluntary does not resolve the question of power. The floor that was built in 1938 has held for 88 years. What is being argued about now is not merely whether gig workers should have more legal protection. What is being argued about is whether the floor exists at all for this category of work, or whether the category itself is a mechanism for removing certain workers from beneath it. The platforms have more money to spend on this argument than any labor movement in American history has been able to raise in opposition. They have spent it in California, in New York, in Texas, in Georgia, in Washington. They are spending it now in federal agencies and in lobbying offices a few blocks from the Capitol. They are doing this because the financial stakes are real. The cost savings from not providing benefits, not covering workers' compensation, not contributing to unemployment insurance, runs to billions of dollars across the industry every year. This is not a philosophical debate for the companies running these platforms. It is a balance sheet question. In 1938, business interests also outspent organized labor on almost every measure of political influence. The Fair Labor Standards Act passed anyway because the conditions of the Great Depression had made the cost of inadequate worker protection visible to everyone simultaneously at the same moment in a way that was impossible to argue past. Those conditions do not exist right now in the same form. The cost of gig worker classification is distributed across millions of individual workers, largely invisible to people who aren't experiencing it directly, and does not produce the kind of shared national emergency that makes political action feel urgent. There is a version of this story that is easy to tell. In the easy version, corporations are the villains. and workers are the victims, and history is simply repeating itself in a new costume. That version is not completely wrong, but it leaves too much out. The harder version acknowledges that the economy that the Fair Labor Standards Act was designed to regulate, stable, place-based, full-time, dominated by manufacturing, no longer describes how most Americans work. The harder version acknowledges that some forms of gig work offer something real to people who need it, and the harder version still asks, when a company controls the price, the routes, the algorithm, and the kill switch, at what point does the label on the contract stop describing a genuine relationship and start describing a legal strategy? The 146 people who died in the Ash Building on March 25, 1911, were not in a burning building because anyone intended to harm them. They were there because the doors were locked and the ladders were too short, and no law required anything different. The owners were acquitted. The fine for a subsequent violation was $20. After that, we built laws. Laws that said, regardless of what the private contract between a company and a worker says, here is what a company owes the people it depends on to function. We are now in a debate about whether those laws apply when the contract uses a different word for the people doing the work. What we built in 1938, did it protect workers from a power imbalance that made genuine voluntary consent impossible? Or did it create a structure that was always specific to a particular era of work and that cannot be forced onto something fundamentally different without causing its own distortions? And what is happening now? Is it finally updating a framework that was never designed for this kind of work, building something better suited to 2026? Or is it moving the floor,